Hello everyone, I welcome you all to Manu Law Classes Daily Current Affair Analysis. In this particular video, we will discuss July 7th, The Hindu Delhi edition newspaper. So in this particular newspaper, we will discuss news from Khalistan Issue. Apart from that, we will discuss about G20. We will discuss about Uniform Civil Code and Internet shutdown, and also about remission and monetary policy and much more. So without further delay, let's begin our discussion with the very first news that is coming in from Canada, as our spokesman, Ministry of External Affairs official spokesman said that freedom of expression being misused in Canada by anti-India elements. जैसा कि हम सभी जानते हैं, देयर वॉज अ डिपिक्शन ऑफ पोस्टर जो बेसिकली एक तरीके का इंसल्ट था इंडिया के लिए, और उसके डिप्लोमैट्स और डिप्लोमैटिक प्रेमाइसेस पे भी वायलेंस का इंसिडेंस हमें कनाडा में देखने को मिला था. सो बिकॉज ऑफ दैट हमने कनाडा गवर्नमेंट को बोला कि व्हाई दिस इज हैपनिंग. सो कनाडा गवर्नमेंट सेड दैट फ्रीडम ऑफ स्पीच को हम अंडरमाइन नहीं कर सकते. तो इसीलिए बेसिकली इस इशू को उठाया गया है और यहाँ पे कहा गया है कि फ्रीडम ऑफ स्पीच बीइंग मिसयूज्ड इन कनाडा बाय एंटी इंडिया एलिमेंट. तो यहाँ पे दो न्यूज बहुत ज्यादा हाईलाइट होती है. एक तो हमारी न्यूज जो हाईलाइट हो रही है वो आपकी खालिस्तान इशू पे न्यूज है, और दूसरी न्यूज जो हमारी हाईलाइट हो रही है वो ऑपरेशन ब्लू स्टार पे है. सो वी विल डिस्कस इन डिटेल फर्स्ट ऑफ ऑल अबाउट द बैकग्राउंड ओवर द इशू ऑफ सेपरेट लैंड, दैट इज Khalistan or the Khalistan issue. Basically, the demand for the separate country find its root in the partition of India. Indian Sikhs, they were unsatisfied and they did not get any culturally or religiously important autonomous region for themselves. And also there were concerns regarding the administrative issue like the river water sharing with the other state. And to cater all these demands, Punjab was divided into Himachal Pradesh, Punjab and Haryana in the year of 1966. However, the separatist Khalistan or the Khalistanis, they wanted their separate country or they wanted a separate area for themselves. And this Khalistan movement started in the year of 1970s with the help of Pakistan. Basically, Pakistan supported the militant elements with the Jarnail Singh. Remember this name? His name was Jarnail Singh. He was the leader of this particular Khalistan movement, and he was provided weapons and funds from Pakistan. Through this, the Khalistan movement was started. So, to subdue this particular movement or to stop this movement, Operation Blue Star was launched in the year of June 1984. Okay, remember this year, Operation Blue Star. So basically it completed its 39 years or so, more years. It was carried out by storming the Golden Temple. The Golden Temple was the epicenter of this movement during that time. So here basically there was a storming at Golden Temple in Amritsar shrine of Sikh community, and here basically all those elements, all those Khalistani elements, they were removed and their operation was failed. So this is the important point. First, you have to remember about what is the Khalistan issue. Second, you have to remember about the Operation Blue Star, in which year it was carried, who was the leader of Khalistan, and why this Operation Blue Star was conducted. Moving further toward our next important issue, that is with regard to the G20 summit. So basically, the G20 next week, the G20 Sherpa meeting will be held in Hampi, and here basically our India's G20 Sherpa Amitabh Kant, he will basically hammer out a consensus for the joint statement ahead the summit, and all the countries will participate. So here Russia has shown its interest to join this G20 summit, which will be held in the next week. So this point is important. You have to remember where it is being conducted and who is the Sherpa ambassador or the G20 Sherpa. Okay. Moving further toward our next important news that is coming in from the section of 1996 Delhi blast case. We know that in the year of 1996, there was a blast in Lajpat Nagar area. So in that case, particularly Supreme Court basically found guilty 4 men and they were sentenced imprisonment for life without remission. So 2 points is important in this particular news. First one, what is remission? And second one, who are being sentenced for life imprisonment. So these are the 4 names. Remember these names: Mohammad Naushad, Mirza Nisar Hussain alias Naza, Mohammad Ali Bhatt alias Kille, or Javed Ahmad Khan. These 4 names, please do remember about them. And in the 1996 bomb blast happened in the Lajpat Nagar area basically. So basically, we will now discuss about what is remission. Under Article 72 and 161 of the Indian Constitution, the President under Article 72 and the Governor under Article 161, they have the power to grant pardon or to suspend, to remit or to commute a sentence which has been passed by the court. So what power they have? To pardon. Pardon power is specifically reserved for the President under Article 72. Apart from that, the power of granting remission or suspend or commute any sentence, it is given to both the Governor and the President. Okay, so remember the article, it is 72 for the President and 161 for the Governor. So as we all know that state prison or the prison, it is a state subject. Okay, so state government also have some power under section 432 of the CRPC, that is Code of Criminal Procedure, to remit some sentence. So basically there are 3 laws: Article 72 of Indian Constitution, Article 161 of Indian Constitution, and Section 432 of the CRPC. They provide some powers to President under Article 72, to Governor under Article 161, and to the state government under Section 432 of CRPC to remit, lower down the punishment which is given to a person. But as under Section 433A, 433A of the CRPC, it puts some restriction on to whom the remission could be given or to whom the remission cannot be given. So basically there are some restrictions. What are these? When the sentence of imprisonment for life is imposed on the convict for a person, for example in this case there has been a sentence of imprisonment for life, so he cannot be granted remission. Other than that, when there is any death sentence or sentence imposed for death of some person, or if there is a heinous crime which has been conducted by the convict, so in these cases basically under section 433A of the CRPC, the remission can't be granted. Okay, other than that, one important case which you should remember, that is Lakshman Naskar versus Union of India case 2000. In this particular case, SC let down, Supreme Court let down the ground or the 5 ground for remission. That is, first, whether the offense is an individual act of crime that does not affect the society. In that case, remission could be granted. Whether there is a chance of crime being repeated in future. If there is no chance, then remission can be granted, but it can be repeated, then remission will not be given. Whether the convict has lost the potentiality to commit crime, in that case the remission can be given. Whether any purpose is being served in keeping the convict in prison, in that case remission cannot be granted. And also the socio-economic condition of the convict's family. So these are various conditions which has been put forwarded by the Supreme Court in Lakshman Naskar versus Union of India case 2000 to provide grant for remission. Okay, so this is an important article which we discussed. Moving further, we have news coming in from Uttarakhand. So basically this is an advertisement kind of thing, but here you should remember one important term, that is sustainable tourism. What is the meaning of this term, sustainable tourism? Sustainable tourism as defined by UNEP, that is United Nations Environment Program, and United Nations World Tourism Organization, they define sustainable tourism as the tourism that takes full account of its current and the future economic, social, and environmental aspects, addressing the needs of the visitors, the industry, the environment, and the host community. Basically, sustainable tourism होता क्या है कि यहाँ पे हम टूरिज्म को तो प्रमोट करेंगे ही करेंगे, लेकिन साथ में हम इन्वायरमेंट का भी, कि इन्वायरमेंट डिग्रेड तो नहीं हो रहा। अगर कोई टूरिज्म प्लेस में कोई टूरिस्ट विजिट कर रहा है तो वो इन्वायरमेंट को गंदा नहीं कर रहा या नहीं कर रहा। तो ये सारी चीजों को एक तरीके से मद्देनजर रख के सस्टेनेबल टूरिज्म का कॉन्सेप्ट लाया गया है कि आप टूरिज्म को डेवलप कीजिए, लेकिन इट शुड बी सस्टेनेबल फॉर द एनवायरमेंट एंड ऑल्सो फॉर द इकोनॉमिक पर्पसेस। ओके, so you have to remember this particular term in your mind. Apart from that, there is one important news that is about Manas Khand circuit. Manas Khand circuit in the Uttarakhand Kumaon region, it has been developed. So which area is being covered, that is important from you. That is Almora, Pithoragarh, Bageshwar. Apart from that, Champawan, Nainital and Udham Singh Nagar. So here the specific point you have to remember about these sites which are coming under the Manas Khand circuit. Okay. Moving further toward our next article, it is again a kind of advertisement article for the state to show their a kind of their culture and all these things. So what is important for us is this particular term, that is Pattachitra, which has been written over here about Pattachitra. What is it? We have to remember this thing. So basically, it is a folk art tradition of Odisha. Okay, Pattachitra is a folk art tradition of Odisha. It is a folk art or folk painting. Pattachitra is basically a picture which is painted on a piece of cloth. Okay, and this form of art is closely related to the cult of Jagannath. As we all know, recently the Jagannath Yatra was conducted, and Jagannath is the famous deity of Puri, and it also comes under the Char Dham. Okay, so this particular painting, Pattachitra, is dedicated to Jagannath and the temple and his temple at Puri. Okay, so it is believed that it has been originated somewhere around 12th century. Okay, and some of the popular theme of this particular painting is Thiya Badiya, which means that it is a depiction of temple of Jagannath. Apart from that, Krishna Leela is being depicted on this particular Pattachitra, and also Dasavatar painting is also being depicted here, where there is 10 incarnation of Lord Vishnu, it is being shown. And also about the Panchmukhi, it is also represented on Pattachitra painting, which depict the Lord Ganesha and he is depicted as a 5-headed deity. Okay, so the theme is basically the essence of the art form and conceptualizing the meaning of the painting. Maximum time the material used for this particular painting, it is of natural resource. It is made by using natural substance, and there is also some set of rules and regulations for making this particular painting. A floral border is a must, like whenever Pattachitra painting is being made, so a floral border is must, and also the use of natural color is important, and the painting depicts basically elongated eyes, like this, elongated eyes, and also solid shades are being used. So this is about the Pattachitra, and basically it is made on Tasar silk cloth. So this is important from you. Apart from that, remember two schemes which is being provided in this particular article, that is augmentation of basic amenities and development of heritage and architecture. Abadha scheme, this is basically for the Puri infrastructure, Jagannath temple Puri infrastructure, and there is also one more scheme, that is Shri Mandira Parikrama project. So basically it is about Meghnad Prachari, which has been divided into the 9 zones, and there will be an investment of around 943 crore, and it will include basically a green buffer for 10-meter radius near the Antara Prakashana and that will be used for parikrama. So this is important. These two schemes are important. Other than that, they are just talking about the Konark temple or the what are the heritage structure, how Puri is being developed. So that is not important for you. You should remember about Pattachitra, these two schemes. They are the schemes of Odisha government, and that's all is important for you. Moving further toward our next important article from the editorial section. We all know that UCC is in news quite since a long time. So basically, this article points out the condition during the formation of our constitution. So basically, at that time, what condition, what debates was there regarding the Uniform Civil Code? As we all know, Uniform Civil Code is under Article 44. It is Article 44 and it is placed under Directive Principle of State Policy. But it was not the first choice which the constitution framers want to put in, because B.R. Ambedkar, he want to make UCC into a somewhere else, not in the DPSP. He want to make UCC as the deciding principle of constitution. But he also said that he do not understand why religion should be given this vast, expensive jurisdiction so as to cover the whole of life and prevent the legislature from encroaching upon the field. So basically, he was not happy in putting UCC under this particular DPSP, Directive Principle of State Policy. As we know, DPSP or Directive Principle of State Policy is non-justifiable in nature. Okay, so that's why he don't want to put the Article 44 or the UCC under this. And also, K.M. Munshi was in favor of Dr. B.R. Ambedkar, and there was a consensus that reached in the Constituent Assembly at that time that Article 44 should be kept in DPS. So this was major highlight of this particular article. As we all know, UCC will provide, basically it is in the right direction, long overdue, to safeguard the fundamental right of all citizens and reduce social inequality and gender discrimination. So all of them said that if we will not implement UCC, so definitely the right of women will not get equal right as compared to the men, and they will be discriminated. So this was the essence of this particular article. Then we have articles related to the capital account convertibility or the fully account convertibility. Basically, it is about how we can internationalize the Indian rupee. So in this, the author is saying that in the time of 1950s, the Indian rupee was a legal tender and it was used in the transaction of UAE, Kuwait, Bahrain, Oman, Qatar, Gulf monarchy. But in the year of 1959, due to the gold smuggling, the RBI Amendment Act brought in Gulf rupee, and the western region were given this Gulf rupee and they were asked to trade in this. And the holders of the Indian currencies were given 6 weeks to exchange their Indian currency, with the transition happening smoothly. But in 1966, India again devalued its currency, and which caused Western Asian countries to replace Gulf rupee with their own currency. So basically, with the, as we all know, there was demonetization recently happened. You have to tell me in which year our currencies were demonetized recently. So with all these things, and also right now in 2023, 2000 note has been withdrawn. So basically, these all things, they were the confidence in Indian rupees. So the author is just saying that the demonetization of 2016 and all these instances, through this, the other countries are not basically building confidence in Indian rupees. So this is the main reason. And now the author is saying that how we can address this issue. So basically, we know that in India, Indian currency is not fully convertible. So basically, what is the meaning of full account convertibility? You should remember this. Basically, it is allowing free involvement of the local finance investment asset into the foreign asset. For example, if I have something in rupee, so it should be fully convertible, or any Indian currency should be fully convertible into any foreign currency. So that is full capital account convertibility. But India does not permit full account convertibility, and that is the reason we are not able to internationalize our rupee or our currency. So this is the main reason behind that. So the author is saying that the central government and also the central bank should launch such initiative to allow the full account convertibility so that we can achieve or we can internationalize our Indian rupee. And we have a goal to convert full convertibility by 2060. Okay, so this is important here. Please keep in mind. Moving further toward our next important article, that is about internet shutdown. So here, as we know that there has been many instances in which the internet has been shut down in Jammu and Kashmir area, Manipur area, Punjab area. So if we see the data, so around 60% of the internet shutdown across the world took place in India. This is a very huge number, and the internet shutdown is not a small matter because it is basically breaching our constitutional right. Why? Because Article 19 of the Constitution mentions that freedom of speech and freedom to practice any profession is our constitutional right, and Article 21 also protect our right to life and liberty, and it gives us right to live with choice. So if internet is being suspended, then how can we live without choice? So that's why banning internet is not a small issue, it is very big issue. It is breaching our fundamental right. So in the Anuradha Bhashin and the Fahima Shirin case, the Supreme Court said that the internet has to be preserved, the access to internet has to be preserved, and shutdown could not be like arbitrary. It should be having any reason or it should be having any proportionality. Our Article 92 of Indian Constitution also says that there should be reasonable restriction which should be imposed wherever necessary, and the ground include threat to nation, to national sovereignty, integrity and defense, and to avoid incitement or commission of a cognizable offense. So basically, if there is an internet shutdown which is temporary in nature or limited in scope, then it is okay, then it is lawful. But if it is not like that, it is not proportionate, it is not limited, so definitely the government should intervene, the court should intervene. So talking about proportionality, it means that you cannot shut down the internet for cheating, to prevent cheating in exam. As we know, when REIT was conducted, whole internet of Rajasthan was shut down. So it was not a proportionate idea, because you cannot just shut down the internet and say that cheating will not happen. So that is what the government should think or keep in mind, that you should not be arbitrary in your decision. It should be proportionate. Apart from that, the Information Technology Act 2000 maintains that the threat to national sovereignty or the integrity of defense call for website blocking. And also we have rules for website blocking, the temporary suspension of telecommunication services, public emergency or public safety rule 2017. So it says that it should be under something like national sovereignty or a threat to nation, integrity or defense, or incitement of commission. So for preventing cheating, it is not proportionate. So you cannot shut down internet for any reason. Okay. So now the author is saying basically, whenever there is an internet shutdown, there is a recommendation that there should be a committee which should be formed. Like in the Anuradha Bashin judgment, if you are cutting off somebody internet, you should have informed them. And also after the internet has been shut down, there should be a committee formed within 7 days or 1 week or 5 days, somewhere around this, to be formed in order to see. A review committee should be formed within the 5 working days to see if the suspension of internet is right, or we should restore the decision, or we should remove the decision and we should allow the internet. So basically, whenever there is any ITR file on this, so basically whenever we file anything, RT, Right to Information Act, whenever we file anything, so we don't get any reply. The application are basically denied. So this means that we don't even know that review committee is being formed or not. So you have to remember two judgment, that is Anuradha Bashin and the Faima Shirin case. It is related to the internet shutdown. In Anuradha Bashin case, it was said that if internet is being shut down, then you should inform the person that internet is being shut down for this much of time. But it is not so in case of wherever the internet has been shut down. Okay, so this is an important article which talks about the articles related to internet shutdown, that is article 19 and 21, and also the judgments related to it. Okay, moving further toward our next important article, that is with regard to the dark pattern. So basically, what is dark pattern? That is important. We have already discussed about it. Dark pattern is something like which is whenever a design or a user interface technique that is intentionally crafted to manipulate or deceive user into making certain choices or taking specific action that may not be in their best interest, that is dark pattern. So it is basically deceptive in nature. It is giving a false conception or false idea that it is beneficial for you, but actually it is not. For example, whenever you purchase something and something is added in your cart, and if you don't see it, you buy it and you pay for that. Apart from that, something is showing that it has a cost of 230 rupees, but when you add into cart, it increases to 700 rupees. So these are all dark patterns, or these are all false deception, or something we say that it is a technique which is intentionally crafted to manipulate your ideas. Okay, so this is dark patterns, and basically to address this particular dark pattern, the Department of Consumer Affairs and the ASCI have identified the issue, and they will take certain steps. They have also introduced a law because it is against the it is coming under unfair trade practices of the Consumer Right Act. Under the Section 29 of the Consumer Protection Act, it comes under the unfair trade practices, and that's why it should be banned or it should not be used. So this is about the dark pattern. Moving further toward our next important article, that is related to UNCLOS and the High Sea Treaty. So we will first discuss about what is UNCLOS. UNCLOS is United Nations Convention on the Law of Sea 1982. In this particular year, this convention came into sea. So it is basically an international agreement that establishes the legal framework for the marine maritime activities. Okay, so it is also known as Law of Sea. It is also called Law of Sea, and it divides marine areas into 5 zones, that is internal waters, territorial sea, contiguous zones, exclusive economic zones, and high seas. These are the 5 areas in which UNCLOS is dividing the water area or the marine area. So it is the only international convention which stipulates a framework for the state jurisdiction in the maritime spaces, and it provides a different legal status to different maritime zones. And it is also providing a kind of backbone for the offshore governance by the coastal state and those navigating the ocean. India is also a member, or India is also a signatory of UNCLOS. Please remember this. So basically, there were till now 3 agreements which has been passed by or adopted by UNCLOS. That is, first one in 1994 about the International Seabed Authority, and the second 1995 treaties established peace stop agreements. Now this is the third agreement which is talking about marine biodiversity of area beyond national jurisdiction, or simply it is called High Sea Treaty. This treaty aims to address the critical issues such as increasing sea surface temperature, over-exploitation of the marine biodiversity, overfishing, coastal pollution, and the unsustainable practice beyond the national jurisdiction. Because though it is not coming under national jurisdiction, it is a very problematic scenario for whole world, because a rise in sea surface temperature can lead to depletion of the dissolved oxygen in water. So these problems are of national or the international concern, and they are coming beyond the national jurisdiction. So the first step is establishing marine protected area to protect the ocean from the human activities, which has been proposed in this particular treaty. And also there has been fair sharing of the benefit from the marine genetic resources. Now you have to comment it out in comment box that what is Nagoya Protocol and what is its main aim, because we are discussing here genetic resources, so you should know about Nagoya Protocol. Okay, but this particular mechanism or this treaty has not been accepted by all of the countries. USA and Russia are basically opposing this particular jurisdiction, stating that this will hinder their bioprospecting research. So basically, this was in news. So we discussed the key point of this particular thing. You have to remember what is it about, what is UNCLOS, in which year it came into scene, and in how many areas it is dividing the marine water, and also is India a part of it or not. Okay. Moving further toward our next important article, that is coming in from Manipur. US is ready to help Manipur if asked, says Eric Garcetti. So basically, as we all know that there has been a lot of violence and killing in Manipur. So it is raising human concern, and US has said that it will intervene in the matter. Its US ambassador to India, Eric Garcetti, has proposed that they will interfere in the matter. They can intervene in the matter if India will allow them to do that. Okay. So remember the name Eric Garcetti. Okay. Moving further, this is also an important news, as the Supreme Court asked NGO to move center against the issue of Sarpanch Patism in politics. We all have seen the series called Panchayat, and in that we have seen the position of Pradhan Pati. So basically, this particular issue is related to that only. Basically, under the 73rd Constitutional Amendment Act 1992, women were provided one-third quota in village, block or district level panchayat governance. But though they get elected in these seats, but they are not exercising this particular position because their husband or any their male kins, they are exercising the position. So that's the problem which the government is addressing, because they want to ensure women in politics, women participation in politics. But through this problem, the Sarpanch Pati problem or the Pradhan Pati problem, they are not able to implement this particular idea of ensuring women participation in politics. Moving further toward our next important article, that is coming in from international relation. India and France gear up for the Modi visit, and they focus on the key deals. So basically, there is a term that is co-development rather than co-production will be the focus of India-France ties. Please remember this term. Co-development is important than co-production. This is the key India type, because sometimes the question is being asked on these terms. So basically, there is an agreement which has been signed between DRDO and the French defense major Safran with regard to the important technologies that will be seen, like transfer production, and also there will be a technology development issue, and India and France will also strengthen collaboration in space, and the Safran, the company with which India is collaborating or DRDO is collaborating, they will discuss the possibilities of Indian aviation market and how to bring new engine technologies or develop technology, how to develop the engineering sector in both the sides. So India and France will collaborate in defense, energy, space and new technologies. So you have to remember this important deal that is being signed between DRDO and French major Safran. Okay. Moving further toward our next important article, that is coming in from Chandrayaan 3. As we know that Chandrayaan 3, its launch date has been set on July 14. So the ISRO chairperson S. Somanathan, he said basically if there will be launch on the scheduled day, then the lunar landing, then the Chandrayaan 3 will land on the lunar surface on August 23 or 24th, and it will basically stay on moon for 14 days, and it will operate there, study there, and then it will come back. So let's see what will happen when the launch will happen. This is a news in transition, but you should know what is Chandrayaan 3 and who is carrying Chandrayaan 3, which is spacecraft which is being launched by launch vehicle Mark 3 and launch window for the mission is between 12 to 19. So just remember this point. This is a news in transition. So we will discuss later what will happen. Okay. Moving further toward our next important news, that is with regard to the launch of Thread. Basically, it is an alternative for Twitter. Meta, as we all know, it is the company of Mark Zuckerberg. So he is launching an alternative to Twitter, that is Thread. Remember the name, what app it is Thread. Okay. Moving further toward our next important article, that is about Netherlands to return colonial era acquisition to Sri Lanka and Indonesia. Basically, the news comes after the aftermath of a recommendation from a particular commission which said that they will return the important artifacts or art piece or the natural history collection which was done by the former colonial ruler in Netherlands to the respective countries, and they will return the colonial era acquisition to Sri Lanka and Indonesia. And this particular proposal was put forwarded by Indonesia to return these artifacts and artworks to their countries. Moving further toward our next important article, it is dealing with Finance Ministry pushes for reforms to spur FDI or foreign direct investment. So basically, what is the hurdle here? We will see on that. So the basically why FDI is decreasing because of the tight monetary policy. Now we will understand what is tight monetary policy. Tight monetary policy is basically an action which has been undertaken by the central bank, such as the Federal Reserve or the central banks, to the slow down the economic growth. Basically, when there is a lot of inflation, then the central bank, in our case it is RBI, they follow or they use the tight monetary policy or contractionary policy. So through this, basically what they do, they increase the borrowing rate. And they slows down the lending rate. Okay, so keep remember this point. And because of that, basically we are seeing that we don't have enough. We are a kind of FDI. It is being dipped in the last year. Okay, so this is all for today. Stay tuned with Manu Law Classes for further updates. These are important news which we discussed in our session. We will discuss other news in our next session. So stay tuned, stay connected. Thank you.